Hello everyone, we are from Group 2. The members of our group are me, Keylia, Sayidina Islam, Fathihah, Noor, Fern Emmanuela, and also Tatar, Betari, Widhigati. Today we are going to explain the sources of law, but before we explain further about the various sources of law, first thing first, we need to know the definition itself. Based on Christine S.T. Council on her book namely Introduction to Indonesian Law and Legal System, it is stated that sources of law are everything that can lead to coercive rules which, if it's violated, it results in firm and real sanctions. But on the other hand, based on Bagirmanan, it is stated that sources of law are everything that requires caution in making it, so as not to cause mistake, let alone to mislead. Based on these two definitions, we can conclude that source of law is a place to see the embodiment of law that has binding power, so that it is necessary to pay attention to the factors that can influence the law, such as where the law is found and what norms it is based on. In general, sources of law can be classified into two, such as the material sources of law and also the formal sources of law, which will be explained further by my friends. Thank you!
So as we all know, there are two types of sources of law. The first is material law sources. So what is meant by material law sources? The material law sources is the place or origin from which the law is taken. This means it has a close relationship with the beliefs or feelings of each individual's or public opinion that will regulate the content of law. In simple terms, the material source of law looks at the content of law. For example, the criminal code that regulates general crimes and violations, or the criminal code that regulates individual issues with each other, such as engagements and agreements. And are there factors that affect the sources of law? Of course there is. There are two factors that affect the sources of law. The first is the ideal factors, namely the standards regarding the justice of the lawmakers in carrying out their duties. The second is social factors, which is the things that exist in our society and are subject for the community. These are the regulations as a guide to live for the community, such as economic structures and community needs, legal systems of other countries, and legal awareness.
Alright, now let's move on to the next one, which is the formal legal sources. Before we discuss further about the formal legal sources, we have to know first what is meant by formal legal sources. Formal legal sources are the sources of law that determine the form and cause of a regulation or legal rule which is already in force and known to the public, where each regulation there functions as legalization and legislation, namely ratifying existing laws in society and processing law enforcement as the purpose of criminal procedural law. Currently, Law Number 12 of 2011 is a guideline for the legislative institutions when forming legislation. So, are there any factors that influence the formal legal sources? Yes, there are. Here, let me explain to you. Similar to the factors that affect the material legal sources, the factors that affect the formal legal sources are also divided into two. The first one is the social structure that forms the basis for the existence of society, such as social stratification, social institution, culture, and also power and authority. And the second one is good and bad values for society that need to be harmonized, such as freedom and order, general and specificity, protection and order, etc.
What are the types of formal legal sources? There are 5 types of formal legal sources that are well known in the science of law. The first one is law. It's a state regulation made by PR with the president as an additional rule, further from the 1945 Constitution, which is coercive and binding. The law has a role as regulator of community life in order to realize the goal of the state. The second one is habit. Habits are the same human action done repeatedly and liked by the society in general. What is considered a violation if there's an action that contrary to habit, then the habit can be called a legal habit. The third one is jurisprudence or judge decision, namely regulation containing previous judge's decision and face a case regulated in the law, which is then used as a guide for judges others to solve similar problems. Jurisprudence exists because there is legal ambiguity prearranged, making it difficult for judges to make a decision. And then there is treaty, namely an agreement between countries that is set forth in a certain form and requires the country concerned to comply with the contents of the agreement. It is the same with the agreement on, in general, which has the principle of pacta sunt servanda, which means every agreement must be obeyed or kept. The treaty also adhere to this principle. There are three types of treaties, namely bilateral, multilateral, and collective treaties. The last one is doctrine. Doctrine is an opinion issued by a well-known legal expert, and doctrine is related with jurisprudence, that is, as the material usually cited by judge in making a decision. Because doctrine can be a source of law if it doesn't have binding power like a law, while the judge decision or jurisprudence has binding power as constitution. That's all from us. Thank you so much for watching, and I hope it is useful. See you next time.